Guys, welcome back to our YouTube channel. We are back with another analysis on what has happened today in court. I think it was quite an interesting day and a long day for both the judges and counsel who were present in court, and I think sometimes or most of the times they found comfort in, making fun of one another. Sometimes you could feel like tension was a bit high. And that usually happens. That is the nature of practice. You have to defend the interest of your client zealously. And indeed, that is what we are seeing. However, I have to admit, and I've come to the conclusion that the team of the deputy president played this game so hard, they've ended up playing themselves. Now, before I delve into the analysis for today, do kindly subscribe to our YouTube channel, leave a like and a comment. Also click the notification bell so that you're notified whenever we post. I believe you've done so. So basically today we were dealing with the issue of recusal. So for those who do not know what recusal means, it's a legal term that when a party feels that a judge or the bench is biased against them, they can apply to that very judge or to the bench, that very bench, to remove themselves, so that a set of new judges or another judge comes on board to hear and determine a matter. So there are several steps there are standards that one has to meet before you apply or make an application of such nature. But we did expect and we did tell you that in this particular proceeding, we are going to see so many applications coming in a bid to drag this case beyond its reasonable time. So they want to really drag it as much as possible because then that works for them. So there was this general belief within that team that this particular court was going to extend the conservatory orders, because all along they've been enjoying this conservatory order. So the first fundamental mistake that they made is that they put in an application to declare the bench which is hearing this matter as unconstitutionally formed or appointed. So that application, when it came up on Tuesday, was discussed, parties submitted on it, and then on Wednesday, the court gave its ruling. So, mark you, when they made this application, what was to be heard on Tuesday was an application by the Attorney General and the National Assembly to have the conservatory orders lifted. So the lifting of the conservatory orders would have ended up really removing or defeating the substratum of the case, because it would allow the swearing in of Professor Kindiki as the next deputy president. So then what they did on that day, they went ahead and tried to bring up issues to grandstand, and they ended up having the application to declare the bench as unconstitutionally constituted by the DCJ, and that ate into the time. So they didn't realize that the conservatory orders actually were to lapse today, the 24th. So when a suggestion was made by counsel of the National Assembly, Professor Githu Muigai, that the application for recusal and that which was challenging the constitution of the bench itself by Lady Justice DCJ Mwelu, to be heard together, they refused. So they said, no, we cannot hear them together. What we do, why can't we hear this our application first? So because in the event you find yourself to have been unconstitutionally constituted by the DCJ, then there would be no need to go into the application for recusal, because then it would be rendered moot. That question would be rendered moot. So the court adopted that approach. it went ahead, had that application, and dismissed it. So then it opened the door for the application for recusal, which now we were hearing today. So you see, all this time is running against the order, the conservatory order. So in their application for recusal, they are accusing the judges of being biased. They are essentially challenging the judges for being bad against them. So then there is an application before them for recusal, which have to be heard first before the judges can proceed and hear any other application, because an application for recusal is a serious one, because you are essentially bringing or accusing the judge or the bench of being biased against you, and essentially saying that they are not capable of considering whatever thing that relates to a case before them objectively. So then, somehow, it also acts as a block. So it blocks the judges from also delving into any other issue that touches on the case itself. And that includes the application to lift the conservatory orders. So far, we were to hear the application to lift the conservatory orders on Tuesday. The reason why we have not heard the arguments relating to that particular application is because the petitioners believe that the bench is biased. Now, on to the main point. Why do we say that they played the game so hard they ended up playing themselves? This is the catch. When the arguments closed, you saw senior counsel Paul Muite making an application before that very bench to have the conservatory orders extended, because those conservatory orders lapse tonight. So by midnight, there would be no order stopping Professor Kindiki from taking up office or from being sworn in, unless another order would be made by that very bench. Right now, there is none. All of them would lapse tonight. So essentially, it would be paving a way for the swearing in of Professor Kindiki. So unless something extraordinary happens, but there would be nothing now stopping the swearing in of Professor Kindiki. Now, the bit of that is the bit of they played the game so hard. So they played the game so hard by, trying to frustrate the whole process and trying to, drag this matter so that the application to lift those conservatory orders is not heard. Now, how did they end up playing themselves? They ended up playing themselves by making their application for extension of those orders before the very judges they accuse of being biased. So they are telling the judge that we know you are biased. You are not supposed to deal with that issue because you are biased. But at the same time, they are now telling the judge, but you see, why don't you extend these orders for us? So you are biased, but when it comes to now us seeking some assistance, then we can throw this allegation of bias against you, and you can act in our interest. You cannot have your cake and eat it at the same time. Something has to give. So what happened? They ended up playing themselves. It was so easy. So Professor Githu Muigai stood up and said, no, that cannot happen. If this court is bad for this, it cannot be good for another thing. So it has to be bad. If the court is bad, it is bad for everything. It is bad for even considering an application to extend those conservatory orders. And that is a valid argument. So right now, Professor Kindiki can be sworn in tomorrow at 8. Let them swear in Professor Kindiki so that you take this game from their hands. So that this dragging this matter, politicizing and playing to the gallery comes to an end. So that we hear the substratum of the case as it is. Because once that happens, there would be no need for this lot of, for these games, for these applications. There would be no need for them. That is our humble view on this matter. Do leave a comment, as you said, and also leave a like. Thank you very much.